Hello, my name is Mason Waring, and I'm an attorney and partner at Chisholm & Kilpatrick. I'm joined here today with my colleague, Leah Small, who's also a CCK attorney. We devote much of our law practice to representing individuals with their long-term disability insurance claims. These are individuals who either purchase coverage themselves from an insurance company or they receive coverage as a benefit of employment from their employers. Now they're disabled and they're seeking benefits, and they're either making initial claims, they're appealing a claim denial, or need to go to court. If you have a long-term disability claim, if you are going out of work and think you may have one, and you want to talk to a lawyer, it costs nothing to talk to us to see if we can assist you. Please feel free to reach out. You can reach us online at cck-law.com or on the phone 401-331-6300. Today, we're going to talk about 7 common mistakes that people make when handling their own long-term disability claims. And it seems a little odd to talk about the mistakes. We usually focus on what you should be doing, but hopefully thinking about these things will help individuals handling their own claims do a better job and avoid some of these common pitfalls. And even if you're considering contacting a lawyer and getting assistance, thinking about these 7 items will help you make your claim as strong as it can be and will allow a lawyer to help you better. So let's get started here today. Number 1, the first common mistake, failing to understand your definition of disability. Leah, could you talk more about that?
Sure. So long-term disability policies typically have 2 definitions of disability that frequently appear. First is the own occupation definition of disability, and that asks whether you're able to perform the material duties of your own occupation, which is traditionally the job you were doing at the time you became disabled. We also frequently see the any occupation definition of disability, which asks whether you're able to perform the material duties of any occupation. Sometimes the any occupation definition includes what we call a gainful component, which means it asks whether you can perform any occupation that earns you a certain percentage of your pre-disability earnings. And sometimes it also includes and takes into account your training and education experience. In many disability policies, especially the ones that you get as an employment benefit from your employer, it starts as the own occupation definition of disability and then transitions to any occupation after a certain period of time. Oftentimes, though, we encounter claimants who really focus on the job they were doing when they become disabled and why they can't perform that job, even though that may no longer be the applicable definition of disability. And when you're filing a claim, or if you're already on claim and you're doing an update with the insurance company, you need to explain why you meet the applicable definition of disability that matters at that time. So it's really important for claimants to read their policy and understand what definition of disability currently applies to them so they can do that successfully.
Leah, if a claimant's trying to figure out what the material duties of their own occupation were, are they restricted to only looking at their job description from their employer?
No, although that can be a great place to start, it's also useful to just think about what your day-to-day looked like and what was required of you cognitively and physically in performing your job duties. One other thing to be aware of, in many disability policies, it looks at your occupation as it's performed in the national economy rather than how it's performed for a specific employer. So if you have very specific duties that your employer required, but generally someone in that occupation doesn't have those duties, those may not count towards whether you can perform that job for purposes of your long-term disability benefits.
And sometimes we engage vocational experts to help evaluate the duties of the occupation and really, plug the holes where there are holes in the job description, or where the job description doesn't accurately detail the material substantial duties of the job. Great. Let's move on to number 2, common mistake number 2, excluding some of your disabling medical conditions.
So a lot of times claimants have one main condition that causes them to stop working, but they often have additional medical conditions that also negatively impact their ability to work. If you only focus on that primary condition, you're not providing the insurance company a full picture of your disability. So you want to make sure that you're including all of your medical conditions in your disability claim and explaining in detail how each of them impacts your ability to work.
And some claims can be complicated. There could be, medical conditions that are part of your picture that maybe aren't relevant to the disability picture. That can be a good time to contact a lawyer to talk through and get some professional help to understand what to include and what not. But a good rule of thumb is, we are complicated beings, and both emotionally and physically, different things can contribute to your ability to work or interfere with your ability to work. And so you want to take all those into consideration when you think about what you're going to base your claim on. The common mistake number three, using inaccurate language. Leah, tell us about that.
So oftentimes claimants will, in their disability claims or in their updates, will say, I always do this, or I never do that. And a lot of times that stems from the fact that it's such a departure from how they were prior to their disability. But usually that statement isn't accurate. Usually what they really mean is that they usually do something or they rarely do something. Problems arise when claimants use that type of absolute language that's actually inaccurate when insurance companies do surveillance on claimants, and they might see them engaging in an activity that they report they never do. And the insurance company will then try to use that against them to say the claimant is not reliable, they're not honest, can't trust what they report. So instead, you want to make sure you're using precise, accurate language that correctly describes your conditions, your symptoms, your impairments, and your activities.
Right. And it really, to put it in practical terms, you don't want to talk to the insurance company or write to the insurance company the way that you would talk or write to your friends. And if you're talking to let's say you had bad back pain and you're talking to your friend on the phone and you said, I just can't lift things anymore. You probably don't mean you can't lift anything. You may be able to lift light weights. You might be able to lift things infrequently. You just can't lift as much as you did before or as frequently as you did before. And so you're not lying to your friend. That's just how you express yourself to your friend. If you say that to the insurance company, they're going to take that literally and mean you cannot lift anymore. So if you are, I don't know, if you're at the grocery store lifting a half gallon of milk, you're now lifting something. And what you've said is not accurate. So you just really want to be careful to be accurate in what you're reporting to the insurance company and not communicate with the insurance company the way you would communicate with your friend. Be more precise. Number four, common mistake number four, poor communication with your doctors.
When we're dealing with these disability claims, medical records from your treating physicians are the foundation of your claim. And the insurance company is going to be looking at those records to see what is documented and to determine if disability is supported. You want your records to be detailed and include descriptions of all your symptoms and your resulting limitations from those symptoms. But we often have claimants who tell the doctors, oh, I'm doing okay, I'm doing fine. And that can happen because a lot of people don't like to complain, or because they've just accepted what their condition is now. And so in their mind, they are okay in the sense of their new normal, even if it's a large departure from how they were pre-disability. Oftentimes we also see claimants who assume if they told their doctor something before, their doctor's still going to note it now, so they don't have to repeat it at each appointment. The problem is oftentimes doctors will only record what you report to them during that specific appointment. So you might not have your symptoms and limitations noted if you don't actually report them to your doctor during that appointment. And if it's an initial claim, the insurance company might look at that and say, your records don't document very much, so you must not be disabled. Or if they're reviewing an existing claim, if there's been a shift where symptoms and limitations aren't noted anymore, they might say, oh, you've clearly improved, so we're going to terminate your benefits. So even if it feels repetitive or like you're saying the same things over and over again, each time you go to your doctor, you should accurately and in detail describe your conditions, your symptoms, and how those limit you.
And it might be helpful to keep a symptom diary. If you have a chronic pain or fatigue or any number of symptoms, it can be really helpful to keep a diary, because if you see your doctor once every month, you may forget, what happened over the 30 days. And also in your appointment, you may just not remember all of your symptoms. So a symptom log can really be helpful in facilitating that communication. And if you can't do that, at least, keeping a checklist of what your symptoms are, and you can bring that with you. You can bring your notes to your appointment so that, you can just remember to talk about your doctor, and not just your symptoms. It's just a good practice anyway. What medications you're on, how you're sleeping, things like that. Those are really good data points for your doctors to have. And if you have a list, you're going to make sure it's accurate and complete. So just a good thing to keep in mind. Moving to common mistake number 5, and that is relying on the insurance company to gather your evidence of disability. Leah, why is that a mistake?
So insurance companies will often request medical records or information from treating physicians on behalf of claimants, but ultimately it's the claimant's responsibility to submit evidence of their disability to the insurance company. So you don't want to assume the insurance company is taking care of it, I don't have to worry about it. You want to make sure you're following up with your doctors, that they're responding to the insurance company's request in a timely manner to ensure that all necessary information gets to the insurance company in order for them to make a decision on your claim. And this can apply not only to medical records requests, but if your doctors need forms that have to be filled out for the insurance company, like I said, you want to be following up and making sure they're actually doing that, even if the insurance company tells you, we requested that information for you.
Great. And when we represent claimants, we often gather the evidence ourselves and submit it. So even when the insurance company asks for an authorization to collect it themselves, we don't want to just wait and rely on them to gather the information. First, it may get delayed. They may be busy. The claims handler could be busy, but a mistake could be made. And so it's a good idea, if you're helping yourself, to collect your own records, gather them, make sure that it's complete, because sometimes the doctor's offices and hospitals sometimes rely on third parties to fulfill the medical record requests, and sometimes there's errors and you don't get the complete set of records that you asked for, so you really want to make sure it's complete. And then you also don't want to delay. And so when we're handling a case for someone, we like to gather all the records we can ourselves, package them up, and ship them off to the insurance company as efficiently as possible to make sure that the claim's not held up.
Yeah, and one other point related to that is that it's sometimes easier for doctors' offices to kind of push off a request from a third party like an insurance company, but they may be more likely to respond to make sure it gets done if it's coming from the patient themselves. That's why it can also be good for the patient to reach out to try and make sure everything's getting done appropriately.
Right, and some of you may have access to a patient portal from your doctor's office. Just be careful to make sure that everything's in there. I think there are instances where sometimes the patient portal doesn't have the complete set of the records, so sometimes there's more information you might want, and you may need a separate request. And you probably could just ask the office administrator for your doctor whether all the records are actually in there. But if you have that access, particularly if things are shut down due to a pandemic, it could be a real efficient way to gather your own medical records that way. So good things to keep in mind. Moving on to common mistake number 6, ignoring information requests from insurance companies or missing deadlines. Tell us about that, Leah.
So this seems like a pretty basic point, but if an insurance company asks you to complete forms or provide information to them, you should do that to the best of your ability. And if you're unable to obtain that information by the deadline the insurance company gives you, a lot of times claimants might say, it'll be fine, I'll just get to them when I can get to them. But missing deadlines can result in claim denials or benefit terminations. So if you need additional time because you can't meet the insurance company's deadline, you should communicate that to the insurance company rather than ignoring the request, and get confirmation that you have an extension in writing from the insurance company.
Yeah, sounds super simple, but it's super important to do that. And this little nugget of advice really could save a lot of needless claim denials, I think, because our sense is that a lot of these insurance companies just have checklist items that if they don't get a response to an information request by a certain date, automatically a termination letter goes out. And you can avoid that by just reaching out and getting an extension, communicating that you're working on responding to the request. That can avoid a lot of hardship and expense of having to deal with an appeal down the road. So certainly keep this in mind. Common mistake number 7, last but not least, focusing on your aspirations rather than your reality. This sounds a little I don't know, obtuse, but it makes a lot of sense. Leah, tell us why.
Yeah, so many of our clients and just many people in general are hardworking professionals and they don't want to stop working, but a disability has forced them to. And oftentimes, people have a strong desire to return to work, which, we always tell our clients is great. And if you can do that, you absolutely should. But those desires can also negatively impact disability claim. We have claimants who they delay filing a claim because they think they're going to improve and they can go back, so they don't need to bother spending the time. But as we just discussed, there can be strict deadlines involved with these claims, and if you miss a deadline, that could mean a claim denial. Alternatively, we have clients who they're on claim, but they say, I want to try and go back to work. And again, that's great if you're able to, and we encourage that. But a lot of times this will occur before they're actually ready. And insurance companies will unfortunately try and use whatever you do against you. So if you try and go back to work while receiving benefits, because some policies do allow you to work and still receive benefits, that doesn't mean the insurance company won't try and say, nope, you're fine now, so we're going to terminate. And even if you try and fail, the insurance company may have terminated benefits in the meantime, and now you have to go through an appeal process to try and get benefits reinstated. So our advice to clients is often, don't let your aspirations for the future get in the way of your current reality. You have to really think about, what are you currently capable of doing? Even if you have this very strong desire to return to work, just be realistic with yourself about whether you're capable of doing so.
And it's important, if, let's say you're on claim now and you want to return to work, you feel you're ready to return to work, make a return to work plan with your treatment providers, with your doctors. Don't just beg your doctors to clear you to go to work, because in some cases that may be perfectly appropriate. But if you have like a chronic pain condition or something where symptoms can vary or symptoms can be aggravated by doing your job, you really want to almost have a test period and make sure that you're having regular touch points with your care providers. You're monitoring how your symptoms are. That way, if you do not succeed, everything is monitored. You can make sure you're returning to work safely. You don't want to return to work and get injured, and you want to make sure that all your care providers are on board and providing you with the best care that you can have. The benefit to taking care of your health in that way is that you get a good record that can be useful for your claim. So if you do return to work and you're not successful, hopefully that's a bridge back onto your benefits. Now, as Leah mentioned, some policies allow you to collect benefits while you work, partial disability or residual disability. It's called different things in different policies. But some don't, and in certain instances that can result in ending your benefits. So you really want to pay attention to what your policy says and just understand what the ramifications are to making those changes. At the end of the day, if you are able to work, if you are not disabled, you may very well want to do that, and in some instances should. But it's important to take into consideration what kind of coverage you have. This is looping back to the definition of disability. And so you could potentially be able to work in another occupation, but not be able to do your own occupation. And in some instances, you could still collect your full benefit, and others, your benefit will be reduced by your work earnings. So there's a lot of factors to consider. You want to read and understand your policy before you do that. You want to have a really good, clear communication with your physicians and have a plan and see them regularly and communicate that. I guess the only other thing I'd add to this is communicate with the insurance company. So after you've read your policy, you've talked to your physicians, and you have kind of a plan, you really want to communicate your return to work effort in many cases to the insurance company. You don't want them to surveil you or to find out during a review that you've been working for a few months. It's a good idea to make sure everybody's on the same page, put a solid plan together, and bring everybody in the loop. There are exceptions to everything we said here today, which is why it's a really good idea to talk to a lawyer. We counsel people on these matters every day, and there's really no one size fits all to these claims. There's a lot of variability in terms of the policy structure and your unique health situation. But hopefully these things these are good general principles that you should be able to apply here, and we hope this helps. Well, Leah, could you recap the 7 common mistakes for our viewers?
So number 1 is failing to understand your definition of disability. Number 2 is excluding some of your medical conditions from your disability claim. Number 3 is using inaccurate language. 4, poor communication with your doctors. Number 5, relying on the insurance company to gather your evidence of disability. Number 6, ignoring information requests or missing deadlines. And number 7, focusing on your aspirations rather than your reality.
Thank you, Leah. And if you're watching this and you want to talk to us about making your long-term disability claim, if you need help with an appeal of a denied claim or need to go to court, please give us a call, 401-331-6300, or reach out to us on the web. We're at cck-law.com. It costs nothing to speak with us to see if we can assist you. Thank you all very much. Have a good day.